Hello viewers, today we will be discussing the topic Indian Federalism and Emergency Provisions. Proclamation of emergency is a very serious matter as it disturbs the normal fabric of the constitution and adversely affects the rights of the people. Now it is imperative to understand how the imposition of different kinds of emergencies affect and influence Indian federal functioning. Now, Dicey referred to federalism as a weak form of government as it involves division of powers between the center and the states. But then we need to note that for different kinds of emergencies, we have to create situations and provisions to tackle them. The Indian Constitution contains wonderful provisions to tackle with various kinds of national, state and financial emergencies. Now, these emergency provisions transform the Indian political system from a federation to a unitary form of government depending on the exigencies of time. Now, please remember students, there are times when the country unexpectedly and suddenly is overtaken by events when the normal functioning of the constitution, the different organs of the government cannot take place. Besides, the security of the citizens are also endangered. Such situations demand special provisions to tackle and overcome them. Emergency situations place democratic governments in a real dilemma by bringing about a conflict between the primary obligation to protect the integrity of the state and an equally important obligation of protecting the fundamental rights of the citizens and other persons living within its jurisdiction. The state is forced to make a choice between competing values and sacrificing of one to the other. That is the rationale of emergency provisions which one finds in our Indian Constitution and wherein we feel that different kinds of situations demand different kinds of provisions to tackle and overcome them. Now, emergency provisions is a unique feature in the Indian Constitution that allows the union government to exercise wide powers not only in central functioning but also in state or provincial functioning in order to handle the special circumstances. In emergency, the center can take full legislative and executive control of any state. Emergency provisions also allow the center to curtail or suspend the fundamental rights of the citizens. Now, we need to understand that existence of emergency provision in the Constitution is a big reason why academicians are hesitant to call the Indian Constitution as fully federal. Now, the Indian Constitution provides for three kinds of situations and three kinds of emergency provisions. These are abnormal conditions which can lead to a crisis situation. For instance, there can be an emergency as a result of war or an external aggression or an internal rebellion. The Constitution calls it a national emergency under Article 352. There can be a failure in the constitutional functioning of the state. The Constitution calls it a state emergency under 356 of the Constitution. Furthermore, there can be another kind of emergency which is a financial emergency under Article 360 of the Constitution. Part 18 of the Constitution permits the state to suspend our civil liberties and application of certain federal principles during presidential proclamation of emergency. Now, Articles 352 to Article 360 provides for various kinds of emergency related provisions. Let us try to understand these provisions and also analyze their impact on the Indian federal system. Let us start with national emergency, which is contained in Article 352 of the Constitution. National emergency deals with constitutional provisions that can be applied whenever there is an extraordinary situation that threatens the peace and stability of the country. Under Article 352, the Constitution provides for the imposition of emergency when the following conditions are present: war, external aggression or internal rebellion. Article 352 further provides that if the President is satisfied that a grave emergency exists whereby the security of India or any part of it is threatened due to outside aggression or armed rebellion, he may make a proclamation to the effect regarding the whole of India or a part thereof. However, subclause 3 of 352 provides that President can make such a proclamation upon the written advice of the Union Cabinet. Such a proclamation may be placed before each House of Parliament and must be approved by each House within 1 month of the declaration of the proclamation, otherwise that proclamation will expire. It should be noted herein that in explanation of Article 352, it has been provided that for proclamation of emergency, it is not necessary that external aggression or armed rebellion has actually happened. It can be proclaimed if there is a possibility of an happening of an external aggression or an armed rebellion. So even without the occurrence of such an event, a national emergency can be imposed. In the case of the Minerva Mills versus Union of India, it has been held that there is no bar to judicial review of the validity of the proclamation issued by the President of India under Article 352 Clause 1. However, the court's power is limited only to examining whether the limitations conferred by the Constitution have been observed or not. It can check the satisfaction of the President is valid or not. If the satisfaction is based on some malified or absurd reason, it is not satisfaction at all. That is what the court has observed. A proclamation can be made by the President of the country, but there are some provisions for that too. The proclamation can be called for only when the Cabinet provides in writing. An oral proclamation cannot happen. Such a proclamation has to be approved by both the Houses of Parliament, and there is a special procedure for doing it. Absolute membership of the total majority of the House plus 2/3 members present and voting. Otherwise, it ceases to expire. In case the Lok Sabha stands dissolved at the time of the proclamation of the emergency or is not in session, it has to be approved by the Rajya Sabha within 1 month and later on by the Lok Sabha when the Lok Sabha reconvenes itself. Once approved by the Parliament, the emergency remains in force for a period of 6 months. The emergency can be reimposed or extended after the particular resolution has been reconvened and resolved and passed by the Lok Sabha and the Rajya Sabha again. So every resolution has to be approved by the Parliament after every 6 months. If the situation improves, emergency can be revoked by the President of India, but there has to be another proclamation for revocation of proclamation. The 44th Amendment Act of the Constitution provides that 10% or more members of the Lok Sabha can make a requisition for meeting the Lok Sabha, and in that meeting, it can disapprove or revoke the emergency by a simple majority. In such a situation, emergency can become immediately inoperative. So, this is another important amendment that has been made. Let's come to state emergency. State emergency can occur on the basis of the governor's report that there is a failure of constitutional machinery in the particular state. It is the duty of the union government to ensure that the governance of all the states are carried out in accordance with the provisions of the Constitution. Now, in the event of the failure of state machinery and the governor sends a report to the union government, a proclamation of emergency is provided by the President, and this proclamation is only for the failure of constitutional machinery. In popular language, we all know it as President's rule. Such an emergency can have the following effects. Number 1, the President can assume to himself all or any of the functions of the state government other than the High Court. Second, it can declare the powers of the legislature of the concerned state shall be exercisable by or under the authority of the Parliament and make provisions necessary or desirable to give effect to such proclamation. However, it should be noted that the President is not authorized to assume the powers of the High Court or put any limitations on the powers of the courts. Like national emergency, a state emergency should also be approved by the Parliament. In this case, approval should be given within 2 months, otherwise the proclamation ceases to operate. During these 2 months, if the Lok Sabha is dissolved, then the Rajya Sabha has to give approval to this proclamation, and when the Lok Sabha reconvenes itself, it will provide approval to this proclamation. A proclamation for state emergency so approved shall cease to operate on the expiration of a period of 6 months. So, just like the national emergency, even for state emergency, the proclamation approved by the Parliament stays in operation for a period of 6 months. Unless revoked, its life can be extended beyond 6 months several times, but in no case beyond 3 years. So, the maximum period that the state emergency can remain operative is 3 years. Thereafter, the President's rule must come to an end and normal constitutional machinery should be restored in the state concerned. The 44th Amendment Act introduced a new provision to put restraint on the power of the Parliament to extend a proclamation issued under 356 beyond 1 year. Now, we need to understand that what is the procedure for revoking state emergency. It can be revoked by a subsequent proclamation. A proclamation under Article 356 Clause 1 expires in any of the following modes. After 2 months of it making, if it is not approved by the 2 houses of Parliament, it automatically will be revoked. Or after 6 months from the date of proclamation, if it is not re-extended, then it automatically stands revoked. Now, we need to move on to a third type of emergency which the framers thought it wise to introduce, and that is financial emergency under Article 360 of the Constitution. It provides that if the President is satisfied that the financial stability or credit of India or any part of it is in danger, then financial emergency can be imposed. Under such situation, the executive and legislative powers will go to the centre. Like the other 2 types of emergencies that we just discussed, the state emergency and the national emergency, it has also to be approved by the Parliament within 2 months. Financial emergency can operate so long as the situation demands, and just like the state emergency, it can be revoked by a future proclamation. But we need to know that till date, financial emergency has never been imposed in India. What is the effect of the proclamation of national emergency is the transformation of the country from a federal to a unitary mode. All powers, executive and legislative, are concentrated in the hands of the centre. The states are denied normal legislative and executive powers. The authority of the centre increases and the Parliament assumes the power to make laws for the entire country with respect to subjects mentioned even in the state list. The President of India can issue directions to the states as to the manner in which the executive power of the state shall be exercised. So, executive of the state function under the direction of the central government and the President. During the emergency period, the Lok Sabha can extend its tenure by a period of 1 year at a time. But the same cannot be extended beyond 6 months after the proclamation ceases to operate. The tenure of state assemblies can also be extended in a similar manner. During an emergency, the President is empowered to modify provisions regarding distribution of revenues between the Union as well as the states. Another very important and pertinent point is what is the effect of the proclamation of national emergency on fundamental rights. Please note, students, that whenever a national emergency is in operation, Article 19 stands suspended. However, it should also be noted that the suspension continues till the end of the emergency. But here again, there was an amendment under the 44th Constitution Amendment Act of 1978, wherein it was stated that the freedoms listed in Article 19 can be suspended only in the case of proclamation of grounds of war or external aggression. Thus, it is clear that emergency not only suspends the authority of the states by taking away their executive and legislative powers, but also transforms the federal structure of the entire country. But emergency provisions are necessary because it helps the government, it equips the central government to tackle and overcome crisis situations. Now, the declaration of state emergency due to the failure of state machinery also has its repercussions in effects. Now, when a state emergency is in operation, the President can assume to himself all or any of the functions of the state government, and he may vest those functions with the governor or any other executive authority. The President may dissolve the state legislative assembly or put it under suspension. He may authorize the Parliament to make laws on behalf of the states. The President can make any other incidental or consequential provision necessary to give effect to the object of proclamation. Now, the proclamation of financial emergency also has its own consequences. The Union government may give direction to any state government regarding financial matters. The President may ask the states to reduce the salaries and allowances of all or any class of officials and persons in government service. The President may ask the states to reserve all the money bills for the consideration of the Parliament after they have been passed by the state legislature. The President may also give directions for the reduction of salaries and allowances of the central government employees, including the judges of the Supreme Court and the High Court. This is an only area where we find that the judges of the Supreme Court and the High Court are affected when an emergency provision is proclaimed. Now, what is the overall impact of emergency on federalism? Federal laws will overrule state laws, and the Union is empowered to govern state policies, state legislations, including policing, because police is a state subject that are normally devolved to the states. The Union is also empowered to take over and completely control the taxation and budgetary revenue policies. The state budget will not be passed when a state emergency is in proclamation. Under financial emergency, the Union is empowered to have the final say so far as promulgation of financial bills or acts approved by the state legislature. So, the powers of the state government is considerably curtailed during a state emergency or a financial emergency. Even the right to challenge the suspension of fundamental rights is also suspended. What it implies is that the right to constitutional remedies is suspended when an emergency is in operation. However, we need to know that this suspension will not work for Article 20 and 21 of the Constitution. Article 20 is rights of accused persons and 21 is right to life and liberty. Now, right to silence, freedom from double jeopardy and freedom from unlawful arrest and detention cannot be altered during this particular period. So, we need to know that while Article 19 stands suspended, Article 20 and 21 continues to operate because these right to life and personal liberty is considered to be the basic right of a human being, irrespective of whether they are citizens or normal human beings. Now, let us try to understand the impact. The Union government may decide to dismiss the legislative functions of a state legislature and impose a federal law. But how long can that federal law be in operation? A federal law during an emergency can be in operation in a state only for 6 months. The state suspension may be renewed at the end of the period under the vote of Parliament indefinitely until such a time when the Election Commission of India can certify the feasibility of holding free and fair elections in the state to reconstitute the legislature. So, here the Election Commission needs to provide a certificate for holding a fresh election in a state which was under state emergency and the normal tenure of the erstwhile state legislature has been completed. Any order to the above effect should, however, be passed by the Parliament as soon as may be after it is made. Now, we have already understood that during the proclamation of an emergency, the entire country is converted into a unitary one. But does it damage the the federal principles? Does it really transform the federal structure of the country? Please remember, emergency is only for a particular period of time, and during that period of time, the situation necessarily demands taking of quick decisions, and unitary powers help it. Article 356 over the years have become extremely controversial. In spite of the safeguards provided by the Supreme Court in the S.R. Bommai versus Union of India 1994 case, we have been found that this particular provision has been misused. Nevertheless, it should be noted that over time, the number of imposition of state emergency in the different states have come down remarkably. The Sarkaria Commission, which was appointed in the 1980s to review center-state relations, also recommended that Article 356 should be used as a last resort. The Commission also suggested that the State Legislative Assembly should not be dissolved unless the proclamation is approved by the Parliament. It further suggested that all possibilities of forming an alternative government should be fully explored before the centre imposes a state emergency on grounds of breakdown of constitutional machinery. The Supreme Court held in the very famous S.R. Bommai case that the Assembly may not be dissolved till the proclamation is approved by the Parliament. Emergency powers have given considerable leeway to the central government to exercise not only executive powers but also legislative powers for the states. Thus, undoubtedly, this emergency provisions transforms India from a federal to a unitary system during times of emergency. Therefore, as there is a provision in other federal constitutions such as that of the Australian and the Canadian constitution that the court should be given the power to agree to the extent the centre can expand its powers, as it will act as a built-in mechanism to check the arbitrary use of the discretionary powers at the hands of the central government under the emergency provisions of the constitution. That needs to be noted that emergency provisions have been provided by the framers of the constitution in order to keep the country equipped to handle unforeseen situations. The country had faced unforeseen situations and it had adequately tackled them. But over the years, imposition of state emergencies had been misused by frequent imposition. However, a change has been noticed after 1994, where it has been found that the imposition of state emergency has considerably declined, and there has been a resonance of federal principles at the centre as well as the state level. Emergency proclamations are necessary in order to tackle unforeseen situations, but then they should not be used beyond a point so as to harm or hinder the normal functioning of the federal structure. Thank you.